I've had 5 minutes for rebuttal, but you can have another number if you'd like.
Well, I was thinking because there's a cross appeal that I would reserve 8 so that I could address both the cross appeal and have rebuttal time.
Please proceed.
Good morning, Your Honors. May it please the Court. My name is Jessie Harrell, and I'm here this morning on behalf of Mr. Frederick Johnson. There's obviously a lot in these briefs that we disagree with Wal-Mart on, and so I thought it might assist the Court to narrow down where we do agree and then talk about the divergent points. I think Wal-Mart and Mr. Johnson both agree that under the McCain analysis, you have a duty if your conduct creates a foreseeable zone of risk of harming another, that you look at foreseeability against actions, and if there is foreseeable risk, you have a duty to mitigate that risk. I don't think that's in dispute. Wal-Mart did not really address our second point of duty, which is that under Markowitz and cases along those lines, that a property owner also has a duty to foresee foreseeable criminal conduct or to take actions to lessen foreseeable risks on their property.
In regards to McCain, I don't want to,
Yes.
I didn't mean to interrupt you. The duty arises from 4 sources generally in the law.
Yes, Your Honor.
And so your premise is that the duty arises out of the facts of this case, correct?
Yes, Your Honor.
Okay, the fourth factor that they
Exactly.
present?
The
Okay.
fourth factor. We're looking at the facts of this case, whether the duty arises. That is not in dispute. We also fully agree that a company's policies and procedures cannot create an independent duty where none exists. There's no dispute on that. So the crossroads we come to is that where there is an independent duty under either the McCain analysis or the Markowitz analysis, can the policies be used to establish foreseeability?
Counsel, I don't understand that statement.
Okay.
As far as the duty analysis, you just said where there is a duty. So you said where we've established Wal-Mart has a duty. At that point, we don't need to talk about foreseeability as it relates to duty anymore because you've said that there is a duty. So can you walk me through,
Yes, because in both McCain and Markowitz, the duty arises from there being a foreseeable
right,
zone
but
of
your
risk.
but your statement presumed that we already had a duty established.
Well, those are the sources of the duty.
Foreseeability is part of the analysis to establish whether there is a duty at all, right?
Correct, but we're distinguishing cases like Pollock versus Florida Department of Highway Patrol, where the Supreme Court first looked at, is there an independent duty here? Because either the Highway Patrol controlled the roads and they had no control of the roads. Here, Wal-Mart has control of the property. They also looked at whether there was a McCain duty because the creation of a zone of risk. And they said, no, there was nothing that the Florida Department of Highway Patrol did that created the risk. So we've set those two types of duty, or sources of duty, aside. So could the policies and procedures then create a duty for your actions to conform to those policies? And the court said no. But that's not what we're asking the court to do in this case. We're asking the court to look at both McCain and Markowitz and those duties, those sources of duty that apply under the law, because here Wal-Mart has not disputed that it took actions, that its associates pursued the shoplifter out of the store, that they did not warn Mr.
Did they go past
Johnson.
the sidewalk?
They did not.
That's what the policy is called for, right? To not pursue past the sidewalk?
That is, but they also call to not pursue someone at all, to not walk more than 10 steps. And so there was a recognition within...
How many steps were taken here from the point of where the receipts were checked to where they stopped on the sidewalk?
I don't think anybody's ever counted that, but that gets into whether they had a duty to conform to the policies, which we're not arguing they did. We're simply arguing that the policies acknowledge that when you escalate an encounter with the shoplifter, when you pursue them, that there is a foreseeable potential for harm to bystanders. And
You decide this de novo, correct?
Yes, Your Honor. Yes, Your Honor.
What is the exact conduct that you're saying Walmart did that created this foreseeable risk here? What is exactly the conduct that you're relying on?
The conduct was in, as we phrased it, escalating the encounter with the shoplifter, which was grabbing onto his cart, causing him to then spin away, violently hit some other shoppers within the store, creating this commotion that caused Mr. Johnson to flee.
So I would kind of agree with you. That would seem to create a foreseeable risk right around the vicinity, where if he hit somebody with a shopping cart, injured them. How do you get out into the parking lot where it appears that Ms. Felder's actions are the ones that created this foreseeable risk rather than Walmart's? How far do we extend that zone out, that foreseeable risk zone out?
Well, again, we can refer to the policies, because the policies say you don't chase into the parking lot because the suspect can
But I
have
thought
it.
the policies didn't establish the duty.
They don't establish the duty, but they recognize that the harm from accomplice waiting in a car is foreseeable, and that's why they say don't go
That's
there.
why they
because
say
you
don't
could get
go,
hurt.
that's why they say don't go past the
Right,
sidewalk.
because you can get hurt. But then you also have to remember that Walmart's loss prevention associate specifically testified that her job was to keep people in the store and to keep them safe, and that is separate and divorced from the policies. And she didn't do that. She did not see Mr. Johnson exiting behind her because she was so focused on protecting products over people when she knew it was her job to keep him
Counsel,
safe.
if I could ask this and frame it this way. Whether there's a policy or not,
Yes.
there is evidence out there of what the accepted industry practices are, whether they're in Walmart's policy or not. Let's say there's no policy here.
Yes.
But the industry practice is that, A, you don't grab the customer, B, you don't grab at the merchandise, C, you don't yell out, call the police, D, you do not run after them. I mean, in this case, this guy could have run over with his cart somebody, right?
Absolutely.
Okay. So, and then, so there's a litany of things here, whether there's a policy or not, maybe you would agree or maybe not agree on. Those are things in the industry, and that's where the tort duty comes in, because doing those things creates the risk. Now, whether this gentleman, no, it wasn't a gentleman, he was a criminal, but whether he ran someone over with his shopping cart or whether he jumped into a getaway car and the person got hit, that's more on the jury's foreseeability issue, in my view at least. But in terms of the creation of the risk, aren't we just to look at those things I've just discussed and that are in your expert's report that says this is what is done in the industry, with or without a policy?
Absolutely, and that's the second place that we diverge from Walmart. The first is over whether policies and procedures are evidence, and the second is over whether the facts alone, aside from the policies and procedures, would give rise to a duty.
Counsel, where do you, and I'm not saying you don't argue that, but your brief is so heavily focused on the policies and
It
procedures.
is.
Where do you, in the brief, in the initial brief, where do you argue that the duty is established
It is.
by something other than the policies and procedures?
It is in the final section of the brief, Your Honor, where we talk about it being, these actions being foreseeable and not just probable.
Well, the last section I think is on public policy.
I'm sorry, then it is not the exact last section. You're right.
The second to last section, although it doesn't reference the policies as much, it still references the policy, so it wasn't entirely clear to me what you were arguing there. And it's also 90% just a discussion of other cases.
Well, because, and the reason that is, Your Honor, is because the trial court felt bound to follow Graham and Lentini. And this discussion, well, the discussion within the brief of Graham and Lentini expressly asked this court to distinguish or recede from those cases because they were very fact-dependent, and they did not set a blanket duty that you can never, that it's never foreseeable that apprehending a shoplifter will cause harm.
So let's say throw the policies out for a minute.
Mm-hmm.
What is, okay, so and I'll go back and read this argument again here, now that you've said that this is, you're saying this is your argument that, hey, even without the policies, there's still a duty here, and I'll go back and read it with that in mind.
Okay.
And maybe that's what it says, I just didn't pick up on it initially.
And there's also the section that discusses Graham and Lentini that specifically asks this court to distinguish or recede from them.
Sure, but that's different than making an argument. But I'll go back and read this section again. But let me ask you this. So if we don't consider the policies, what was timely presented to the trial court to consider? What would you base the duty on? What would your argument be without the policies? That there's a duty here when you're pursuing a fleeing shoplifter. What's the art? Do you have any evidence, or is it just sort of like a common sense sort of argument?
It was really, I mean, the argument was all the evidence of what they did to escalate this encounter. There was video of it. There was
No. So yeah. So in other words, as far as the timely, I mean, in other words, you're saying, look, even without the policies, just a common sense dictates.
yes.
Right.
And one thing that we had argued to the trial court was that one of the ways that you can look at foreseeability is based on what the case law tells us is so happens with so much frequency that you can expect it to happen again. And that was the Bick case that we cited from the 11th Circuit. And we cited that to the court, and that's why we asked the court, and we're asking this court to consider this body of case law out there.
The expert testimony, was that timely offered, or was that offered on rehearing?
The testimony was offered initially. The report itself was offered on rehearing.
Okay. So do you feel that do you see a difference between, let me ask you this. So it seems like there's some cases out there saying, look, just confronting a shoplifter does not create a duty. That there's no foreseeable, that doesn't create a foreseeable zone of risk. The mere confrontation, hello, sir, I think that you have a product you haven't paid for kind of thing. Is that incorrect? Is that law incorrect? Should we disagree with that?
Well, I don't think you need to for purposes of this case. I know.
I agree we don't need to, but I'm as a starting point. Do we agree on at least that a shopkeeper can confront a shoplifter and say, I believe that you have an item that you didn't pay for, or does that create, in your view, a foreseeable zone of risk that the shoplifter is going to take off and hurt somebody?
I think the distinction is in how you said it, Your Honor. If someone approached them and acted reasonably, because absolutely a shopkeeper is entitled to reasonably try to collect its merchandise, but it's a very fact-specific.
What did they do here that was unreasonable?
It
Are you
was
saying they were unreasonable here?
Yes, Your Honor.
And what did they do that was unreasonable here?
The way they grabbed the cart to cause a confrontation, the way they pursued him out of the store.
My understanding from the record is she placed her hand on the cart. So she can't
And she
place
began
her hand-
rifling through his things.
She can't place her hand on
Well,
the cart?
counsel, those weren't, were they his things?
Well, they weren't his things.
I'm
They were
just
things he
asking
had
you,
stolen.
were they his things or not?
Well, they were
Okay.
not his things.
Right,
They were
yeah. So I
Walmart's
guess
merchandise.
to Judge Boatwright's question, I mean, that seems, it's not like they tackled him or attempted to tackle him, correct?
No.
It's not like they had the stereo and they were wrestling with it back and forth and fighting over it, right? I mean, it was simply hey, those aren't yours, and then he jerks the cart away and runs, right?
Right, and it's beyond. They continue beyond that by having multiple people follow him out of the store, yelling for police to be
Yeah, I was
called.
going to say, didn't someone yell for police?
Yeah, someone yelled for police. I mean, even the driver heard it, and he's yelling, go, go, go. And they've recognized that it's foreseeable that there can be a getaway driver. I mean, remember, Walmart knew Miss Felder was there. They saw her in the store and then saw her leave.
Well, Johnson fled the store.
Right, because
of the,
he was afraid.
of the chaos that was created.
Now, counsel, at the point that they yelled for police,
Yes.
wasn't the shoplifter already in flight? That's how I recall the record, but I just want to make sure.
My understanding was it was sort of simultaneous with him, taking the buggy, and they're yelling for police to be called.
Once he jerks the buggy away, he has committed to flight, I think, at that point. So is that when somebody says, call the police, or was it before that?
When they said call the police, I believe it was at that point when he jerks
the
buggy away.
and heads
But
out.
the amount of panic they created in him by pursuing him, yelling for police to be called, I mean, when you have multiple people following you out, it's going to create an increased panic to try to get away.
I mean, at that point, he's been confronted. He's decided to, the cases, it's either the cases or the brief say, describe it as bolting, right? That's already happened.
It has.
So, there's a little bit of a disconnect in my mind between, at that point, pursuing him onto the sidewalk. Now, did anybody actually pursue into the parking lot? Attempt to stop the car or anything like that?
No, Your Honor, they stopped. The car had pulled up right to the store.
They just stood on the sidewalk, right?
Yes.
The Walmart employees did.
The Walmart employees. The
People who
car
were
had
fleeing
pulled
the
up to
store
the
did not stand there, including Mr. Johnson, correct?
I'm sorry?
The people who were fleeing the store fled out into that area where the bollards are and where the car came through and hit. The Walmart employees stayed back because that's what their policy said. But other people fled out into that area, including Mr. Johnson, right?
Correct. And when we're looking at duty and whether your actions create a blanket duty to reduce harm, at a minimum, when you've created this panicked scene.
What I'm trying to do is boil it down, because there's a lot of stuff on the margins here that doesn't seem like it really is dispositive. So I'm trying to boil it down.
Okay.
It seems like we agree that at least up until the point when the Walmart personnel put their hand on the cart, at least up until that point, Walmart has done nothing to create a duty. Do you agree?
Has done nothing to create a foreseeable zone of risk.
Which would be a duty.
Under McCain, but under Markowitz, you still have a duty.
We're talking about McCain.
Okay, talking about McCain.
So at that point, we agree, no duty yet.
Right, you haven't done anything.
None of those things, nothing that happened up until this point, right? The checking the receipt, nothing like that. So I guess your position is the putting the hand on the cart, then once Mr. Johnson bolts, calling for police to be called, and then pursuing, I don't think we know if they ran to the sidewalk or walked to the sidewalk. Do we know that?
Honestly, I think they said they walked to the sidewalk, but the video would be better. Best
Either way,
evidence
they
of that. Pursued him in some fashion.
In some fashion, they pursued. Maybe it wasn't hot pursuit, but they pursued to the sidewalk.
Yes.
Those are the three things that we have to decide de novo, whether that created a foreseeable zone of risk for purposes of McCain.
And one more action.
Okay.
It's sort of in inaction, but in failing to keep the customers inside the store when you have recognized that failing to do so could cause them injury. And so this store associate, aside from the policies, knew it was her job to protect the customers and to ensure that
But
they
the
didn't
policies
leave
don't
the
create a
store.
duty.
Well, that's what I'm saying. This wasn't even in the policy. She said this was her job to do this because she knew that it was foreseeable that people would be harmed if they didn't stay inside the store. And she was more focused on the product than she was on the people.
Counsel, I'm going to...
I'm sorry, I'm so into my time.
No, it's our fault. We've asked a lot of questions. Judge Boatwright has...
I'll get her.
What I'm going to do is, because we ate into your...
We can give everybody a little more.
Yeah, I'm definitely going to... I'm just trying to figure out how much. We're down to 1:46, so we ate in 6 minutes. I'm more than happy to give each side 6 minutes. Is that okay, my colleagues? Okay.
Thank you, Your
And we will add 6 minutes on your rebuttal. We will add, for Mr. Shooker, have 26 minutes. She can use or not use. Hold on just a moment here. I've got to give you up to 26. All right.
May it please the court, Elliot Shirker on behalf of Walmart. Florida case law, going back more than 50 years, establishes that a retailer's employees do not create a zone of foreseeable risk to customers by taking a shoplifter into their control. by taking the shoplifter into their control. For example, in Lentini, when the store put the shoplifter into a conference room, and the shoplifter then bolted and knocked down a customer.
Well, they didn't do that here. There was no control.
That's correct.
Right.
But the point on which Florida law has been well established
Well, you
is that even
might-
doing so doesn't create a foreseeable zone
Might
of
argue
risk.
that grabbing the cart was an attempt to take some control, although I guess it would be control over the product as opposed to control over the shoplifter, correct? I mean, at most, an attempt to take control over the product, right?
Your Honor, at record 322, page 1378 of our appendix, this was the confrontation, if you will. The checker at the front, who's charged with the duty of saying, "May I please see your receipt," was talking to Pitts. And Pitts produced a receipt for 96 cents and had a shopping cart full of DVDs and other merchandise. The checker was told by the loss prevention associate to do what's called at the store Bob and Lisa, to look underneath the packages to see what was there, and she was doing her job. Now, on the next page, this was the control. You can see at record 325, appendix 1381, she was resting her hand on the cart.
So she could see under.
She was resting her hand on the cart.
Is there video of this, or is this just one still photo?
These are all stills from the video.
Okay, so
The actual videos were not
we don't have
introduced.
we don't have the video on the record on appeal, to my knowledge.
That's correct. They were not introduced on summary judgment. The stills were introduced.
So we don't know what happened between that microsecond and what happened before.
We
and
know
after.
from the checker's testimony.
I thought the testimony was that she maybe put her hand on the cart, that's fine, but she went further and tried to start wrestling the merchandise away from this gentleman.
She was looking at the merchandise as she was instructed to do by the loss prevention associate.
So you're telling us today that she did not touch the merchandise, the employee?
But she touched the merchandise. And the shoplifter started to tussle with her, and then in the same movement, jerked the cart away.
Did the shoplifter make contact with her?
Yes, her testimony was that her hand was bruised because her fingers got caught when he yanked the cart away with her hand resting on the cart.
Okay, so she got injured,
She was injured.
and then who started yelling for the police?
She called to the front desk at that same moment, called the police, as he was jerking the cart away and running out of the store.
What does the industry standard say about what we've described to this point?
Well, according to Vilnius, who's their expert upon whom they did not rely, Judge Eisnagel, as establishing the standard of the foreseeability of zone of risk.
It's not timely.
His report was filed on rehearing.
Right, that's not timely.
And he would disagree with even the policy, with even Wal-Mart's policy. Wal-Mart's policy, which is in the record, is that there are 5 points that have to occur before an associate can even approach, much less take into control, a suspected shoplifter. And the the 5th point is that person has to pass the point of no return, so to speak, that is, going past the checker. That's why Ms. Martin, the loss prevention associate, testified that it was only when Pitts pulled away that she went into action. Now, she did not pursue him. Her testimony, unrebutted testimony, is she walked out, stopped on the sidewalk, and tried to get the license plate number. That's the only reason she exited the store at all, was to try to get the license plate number.
I mean, that's still pursuing, though, right? I mean,
It was
there's
pursuing
some-
the situation, but not the shoplifter, because her testimony, if I might, Your Honor, her testimony is, I had seen what happened with him and knew that he wasn't wanting to be stopped. And our policy is that somebody tries to flee, we don't get in their way. That's record 888-89. She said, so I knew the best I could probably do was to capture whatever information I could about the vehicle. That's what she did by going out on
Well, the first person didn't do that.
I'm sorry?
The first lady didn't do that.
She's not allowed to.
Well, so what?
The policy is that
Something
only
she's not allowed to do. That seems relevant to me.
a loss prevention associate can act and interact with a shoplifter. She was told by the loss prevention associate that there was a potential problem.
So she kind of delegated her authority to the,
She did not. This lady's job is to check the receipts. Give her the receipt, look at what's in the bags. There's a 96-cent receipt and a cart full of merchandise. That doesn't add up. If you take my opponent's argument to its logical extent, the only thing that a retailer can do when they suspect someone is shoplifting, and if you take their argument about what they say is the industry standard to its logical extent, is that a retailer has to stand there like this and say, "Have a good day," and let them walk out of the store and perhaps even ask a bag boy to help them carry it out.
counsel, I don't read the briefs to say that in the least. What I think they're trying to say is there's certain things you have to do to de-escalate a situation. You could, so suppose their policy could be, we're going to sit back and do absolutely nothing, and it's just a loss, and we're going to have to write it off. Maybe some people do that because maybe it's too dangerous to pursue. But I don't hear that's what their argument is. What they're saying is that there's these industry standards that were breached here, and we think they created a duty.
That's not what they're saying at all, Your Honor.
Pardon me?
What they're saying, and let me read to you exactly what they say in their final submission, because their position did change somewhat during the course of the litigation. They originally relied on the policy, then they relied on training, and their ultimate position after the trial court not only heard summary judgment, but asked for additional briefing on summary judgment, heard the rehearing, asked for additional briefing on the rehearing to make sure that all these subjects were covered. This was their ultimate position, and this is in the record at 4:30.
Did you say they asked for additional briefing on the rehearing?
The court asked for additional briefing on training. That's correct.
On the rehearing?
Yes.
So that's when the expert report came in, so that was properly put in at the insistence of the trial judge.
No, the expert report came in with the motion for rehearing.
But I thought I just heard you say that.
There was additional briefing. There was another round of briefing after the hearing was heard.
Okay, it's hard to keep track of it all.
I understand, Your Honor. There were two rebriefings. There was rebriefing after the summary judgment. There was a motion for rehearing, and then there was rebriefing but this is what they said, and this is in the record at 431 through 432. It's in our appendix at pages 1479 through 1480. I'm quoting what they say. To be clear, Wal-Mart's policies do not create a duty to act in conformity with those policies. Wal-Mart's training does not create a duty for employees to act in conformity with their training. Then at page 432. Plaintiff is not arguing that the policies or training created any duty on the part of Wal-Mart to act in conformity with those policies and training. What the policies and training show is that it was reasonably foreseeable to Wal-Mart that customers could be injured by shoplifting suspects if the employees did not exercise due care. The harm was reasonably foreseeable to Wal-Mart. It wrote policies and instructed its employees on those very risks. Wal-Mart cannot ask the court to ignore its own admissions. So what they're saying to you is the policy doesn't create a duty, but what the policy is a recognition that there are foreseeable dangers and therefore a duty is created. That is a brand new concept under Florida law.
Well, let me ask you this. Let's assume that a movie theater has, or it could be any type of proprietorship, but a duty not to say yell fire in a crowded theater. Okay, you just don't do that. They don't have a policy, but even if there's a fire, because it creates havoc and people get injured and going out. So the fact that the policy doesn't really matter one way or the other. If the policy, say for example, has 10 factors, number them from 1 to 10, 1 being the most basic responsibility to 10 being, well gosh, they should have had electronic monitors, they should have had helicopters flying around. Okay, basic duty to super high responsibility and duty. Just because it's in the policy doesn't immunize you from a tort responsibility, does it? Because if you have the basic responsibility, thou shalt not yell, get the police, and get everyone upset and run out of the building, you can't immunize yourself by saying, oh, that's in our policy, so therefore you can't sue us for that. Do you agree with that? Do you understand what I'm saying?
Absolutely, Your Honor. The policy, our fundamental position is that the policy shouldn't be considered in determining duty at all.
Counsel, you're just saying they need to rely on other stuff besides the policy. That's what you're saying, right?
Yes,
But that's not my question.
I understand.
Okay, well, let me make it absolutely 100% clear. Let's assume there is a tort duty out there. Call it what you want, to do X in this situation. And it's an industry standard. And I, in my business, adopt that standard in my policy. And then I get sued because I allegedly didn't follow my policy. do I get immunization from tort liability because I adopted the industry standard and that's the one and only standard in my policy, so therefore you can't look at my policy, you can't?
The short answer
Really?
is no.
Okay,
But it's
that's
a little more nuanced than that because the policies have two different roles. We're talking about the role of policy under McCain. Under McCain, policy doesn't create duty, period. If there is an independent duty, then at trial on the proximate cause issue, a policy can perhaps be introduced on standard of care. So it's not that policy's irrelevant.
Wait. Proximate cause is a different foreseeability analysis.
Correct. And that's the only place policy comes in under Florida law. So we're nowhere near that. We're on the duty side. So policy is irrelevant both ways as to duty. The only reason we're talking about policy in this case, to be absolutely clear, because my opponent's fundamental position is that the policy recognizes foreseeable risk and therefore creates a duty. And our argument is that 6 of one thing, half a dozen of another.
Counsel, what if they, put the policy aside for a moment? What if they had argued on appeal and counsel says, and I'm going to go back and look at it, the next to last argument is an argument on appeal that, hey, look, even without the policy, just common sense dictates that at some point you pursue a shoplifter there, you've created a foreseeable zone of risk based on just what we all know, common sense and how, living in society. What do you say to that? If the policy has nothing to do with it, they're not relying on the policy. If they say, hey, but look, appellate court, this is reviewed de novo, and we're telling you that it's just common sense that at some point, and I'm not saying under these facts, but I'm just saying at some, let's say that 10 Walmart employees pursued the shoplifter, hot pursuit, into the parking lot, right on their heels, running full blast, saying, take them down, take them, something like that, right? At some point, they're saying common sense dictates that there is a creation of a foreseeable zone of risk. Is that enough, or do they have to bring an expert to talk about, well, everybody knows that in the industry standard is this, that, and the other? Or can it just be common sense?
It's the fourth McCain factor. It arises from the facts. Yes, Your Honor.
But I'm saying that, right, okay, so yeah, the answer is yes. I mean, at some point, they don't need to offer experts.
There's nothing that requires an expert, Your Honor. The general...
You're just saying that the policy itself is irrelevant to whether a duty has been created.
You said that much better than I've been trying to. Yes, on either side of the equation. And if we're going to talk about common sense or general duty, I'm more than happy to rely on Graham and Lentini because that is Florida law. And my opponent is very frank in saying we think you should depart from Graham and Lentini. We don't think that should be the law of Florida. Well, it has been for 50 years that I am allowed.
Forgive me, I've read a lot of cases this week. Did either one of those cases have pursuit even after the shoplifter bolted? Because that's the word, again, that's the word that's been used in the briefs. After the shoplifter takes off, did either one of those cases have...
No, sir.
Okay.
No. But both of those cases involved taking them into control. It's before we get to how the injury happened in those cases. Those cases allow a shopkeeper to say, come with me. Come into I'm taking you into a conference room and I'm calling the police.
One of the cases is over 50 years old and one was like 30-something years old, long before we have the development of the standards that we have now for handling shoplifters, correct? I mean, they're different districts.
Lentini is 1995, and forgive me if I don't regard that as
time
ancient.
marches on. That's almost 30 years, okay?
Graham, it's true, is 1970. There has never been anything other than that in Florida law.
Well, you say it's the law of Florida. It's 2 district court of appeal decisions under specific facts there without not elaborated much on the facts. Your employee here, though, testified that yes. Is it also recognized that confrontation of a shoplifter can present a danger to employees and shoppers? It can be. Isn't that enough?
That's the policy.
No,
She's talking about the policy there, Your Honor.
No, she's not. This is an independent question. Is it also recognized, not in the policy, is it also recognized that confrontation with a shoplifter can present a danger to employees and shoppers? It can be. Her own testimony established that she even understood.
Your Honor, that's Ms. Martin's testimony, and I'd ask the court to read it in context, because she's not an expert. She's an associate at Walmart, and all that she knows because of the policy and the training. That's what she knows, and that's what she's testifying to throughout her deposition. But of course, Your Honor.
Are you saying that the questions that he's referring to in the deposition, I think they were all kind of preface regarding the policies?
Yes, Your Honor.
Okay.
Yes,
But her testimony-
that's all she knows. She's not an expert.
Yeah, but there's reasons for the policy, and I think the reasons, put aside the policy, the reasons are facts. She knows that in her profession, and I think she is somewhat of an expert on asset protection here. She says, yes, if you confront the shoplifters, it can present a danger to employees and shoppers.
But, Your Honor, that's not Florida law. Florida law says we can confront a shoplifter. Florida law says we can take them into our control, and Florida law says we can call the police.
Not in every situation, in those limited situations of the cases you have, but those are not in this case. And we don't have to follow those cases either, and they're old cases.
Your Honor, it's true that you don't. Of course not. There's no 5th District case that says the same thing. But those are the only cases under Florida law.
It seems to me you characterize their position. I think your position is we can do what we want and don't have any liability.
Not at all. Not at all.
Don't you agree that at some point?
I think that might, excuse me, I think that might be unfair of me to say that, but I think that's sort of where you're headed, is to say, well, you just can't, we can do what we want because these
Not at all, Your Honor. Not at all. My response to Judge Eisenengel's question, if a Walmart associate pulled out a gun and started popping off rounds in the middle of the store, of course that creates a foreseeable zone of risk. But the law is that approaching a shoplifter, doing more than we did, doing more than the receipt checker did, doesn't create the foreseeable zone of risk.
How is this case any different than the Walker versus Feldman case, which is where they had all the shoppers, they said, go, say on everyone, and people got trampled. Why is not yelling, get the police, and Walmart shoppers flee and get hit by their car? Why is that any different from Walker versus Feldman? That's the law of Florida for decades as well.
Your Honor, that's not the same thing, not the same thing at all. We are allowed to get the police. We are allowed to tell the shoplifter, stop.
But you're not allowed to yell, get the police, and create a ruckus that causes people to flee the store.
Your Honor, there's no testimony that I'm drawing a blank on her name, the receipt checker, when she called to the front desk and said, get the police, as he broke away from her and ran out the store, is what created the ruckus. The ruckus was created when he ran out of the store and knocked into another shopper and charged out the door. The shoplifter created the ruckus. We did what we're allowed to do under Florida law and say, hold on a second there, fellow, you got a bag full, got a cart full of merchandise, you just blew right past the checkout, the self-checkout, and you're giving me a receipt for 96 cents.
What do you say to the failure to try to keep, and obviously Walmart can't force somebody to stay in the store, obviously, but what about should have attempted to keep Mr. Johnson in the store? That seems like a separate issue, but what do you say to that?
That argument is completely based on our policy. That argument is the only place that arises from is our policy. And the unrebutted testimony is that Ms. Martin walked out the door. Her back was to Mr. Johnson and everyone else in the store. And he ran past her and ran into the middle of the crosswalk. On his own, running, he was on the other side of the store. He came in on the east side of the store. This whole entire event took about 3 seconds. He was on the east side of the store. He crossed over to the west side of the store, followed the shoplifter out, and ran into the crosswalk.
How do you know it wasn't a shooter or something? People are fleeing because they're up.
This is not criticism of Mr. Johnson. This is a question of what duty we had under Florida law to not create a foreseeable zone of risk.
But don't you think it getting patrons of your store all upset to the point that they think there's a ruckus going on, there may be something they need to flee from, and they would go out into the park, run out into the parking lot? Keep in mind that area has bollards. There's like a dozen bullards there because
Correct.
that's apparently an area that Wal-Mart thinks is very dangerous and doesn't allow their employees to go beyond.
It's a crosswalk. They said the policies don't go running into the crosswalk because you could get hit, you could get hurt.
Right.
Of
I like
course.
that.
But the question is, at the moment of the encounter, that's where the law focuses, the existing law focuses, is on the moment of the encounter. And if we're allowed to walk up under Florida law, if we are, as we currently are, allowed to walk up to a shoplifter and say, come with me, you're a criminal, I'm calling the police, which is what Lentini says we can do. Come with me, I'm going to closet you in a conference room. We're allowed to do that. Then I fail to see how the minimal contact of, may I please see your receipt, what's in your cart, creates a duty that approaching a shoplifter and essentially taking them into custody
What evidence
doesn't.
What evidence do you have that Lentini is now currently the standard of care in this industry? Is what was done there? Can you show that that's the current standard in the industry now, 50 years later?
There's no evidence to the contrary, that Lentini has suddenly turned into bad law, and that literally, Your Honor, and I'm not being flip, a retailer has to say, please go ahead. That is not the law in Florida, and we have Vilnius disagreeing with the law in Florida, and trying to create a duty out of whole cloth that they never actually tried to create. And I read you their position in so many words. Their position is, in so many words, you, Walmart, have a policy. You therefore recognize that all these things are possible. Therefore, there's a duty. That is exactly the same thing as saying policy creates duty. And the reason that policy doesn't, it's not an arbitrary rule. It's not just pulled out of the air. The reason that the courts have declined to create duty out of policy is that gives businesses every incentive not to have a policy. That's the reason for the rule. And if you do the same thing by saying your policy recognizes a risk, therefore you have a duty, you create the same disincentive to have reasonable policies in place. That's the theory on which they've been trying to win this case. Since the last proceeding before the trial court, that's what their brief is all about. We supposedly know that any approach to a shoplifter creates a zone of risk because we created a policy saying, a very careful 65-page policy, saying don't do this, do that, don't do this, do that. If that creates a duty, that's the same thing as saying policy creates a duty. And the reason that we do not have such a rule in Florida is we want businesses to have reasonable policies in place.
Can I ask you about your cross appeal?
Yes, sir, Your
If
Honor.
I could, okay,
And
because you only have 246
as
left.
to your affirmative defense under 768.81, does it matter that she entered a plea to aggravated battery?
It's not, it doesn't, we're not bound by that plea.
Okay, that's not going to, that shouldn't preclude you from being able
Not at
to,
all.
as the appellant has argued.
We're not a party to the criminal case. We're not bound by that plea. That was a plea of convenience. She never accepted responsibility for an intentional tort. She accepted responsibility for her actions.
Did the judge just go strictly off of the video, what he saw in the video, and thought that was uncontroverted, and that's why he made the ruling he did? Is that what his basis was, or was his basis the plea?
The court was very influenced by the plea. We, on the other hand, invoked Scott versus Harris and the change in Florida law. We asked the court to follow what the video shows, what the video stills show, which is completely contrary to what Mr. Johnson
Her
testified.
turning right, correct?
Yes. He was standing in front of her. It looks in one of the photographs as if he's raising his hand toward the car. This was literally 2 seconds.
So your argument, there's still facts in dispute?
Yeah, as to whether it was substantially certain that she was intending to cause his injury or death. Remember, he's standing here. She's driving this way. Her brake lights go on at the same second, because we have the photographs from both sides. The brake lights go on at the same second that he's standing in front of the car. The exit's here. He's between her and the exit. She turns to the right. He's going back and forth in the crosswalk, and that's when the impact occurs.
And her testimony was that she didn't intend to hit him. She was just trying to get out of the way.
And she pulled away down a different way, down a line of cars as opposed to going out the exit, which is completely consistent.
So you want her on the verdict form?
Absolutely.
To have the comparative negligence?
Absolutely, Your Honor.
But what about Mr. Johnson? Why do you want him on the form?
Well, there was no dispute as to whether Johnson could be on the form on comparative negligence. That was never even an issue.
Well, I'm asking, what was his negligence?
Walking, dancing back and forth in the crosswalk.
Well, I've seen the video. He was trying to avoid the car about to run over him.
Well, he goes into the crosswalk, he goes like this, he goes back and forth, and then he's hit. But the question whether he should be on the verdict form isn't on before the court on this appeal.
Okay, I was just curious. Thank you.
Thank you, Your Honors.
All right, thank you. Didn't think we'd be keeping you here overtime, huh?
My pleasure, Your Honor.
This is great, thank you. All right. And you didn't have any time reserved for the reply on the cross appeal, but,
In my experience, usually there's no...
well, if something, I mean, I'm willing to do that. So we've given you additional, was it 6 minutes?
Yes, Your Honor.
Okay. Oops. Okay, that'd be 8 minutes. Hold on. This clock is not, let's see, I got 1:46, so I'm just going to punch it, and we're going to go to -5. So go ahead and start.
Okay.
Counsel, I'd like to
Yes.
just get clarity on the,
Absolutely.
on the briefing again, similar to my prior question of like what is actually raised in the initial brief.
Yes.
I definitely don't see an argument in the initial brief based upon industry standards. And I did a search of the initial brief right here, and industry standards is only mentioned in the procedural history. Am I missing it? Is there an argument that there was a duty based on industry standards made in the initial brief?
No, Your Honor.
Okay.
No. But what was raised in the initial brief is, again, our argument that these policies do not establish the standard of care, and that is where Wal-Mart is conflating these things. You absolutely cannot take Publix's policy to escort shoppers into the parking lot and then someone hurts their back and say they had a duty to escort the person into the parking lot. We don't do that. We don't discourage, or there was nothing they did that placed somebody in a foreseeable zone of risk. But what Wal-Mart is asking this court to do is allow them to make admissions in their internal documents that certain outcomes are foreseeable, and then come into court and say,
Counsel,
there's no foreseeability.
I understand that part of your argument, I do, but here's the problem with that. It presumes that policies are admissions and that they only cover what is reasonably foreseeable. I mean, I think your opposing counsel's argument is simply this, that we want Walmart and other entities, large and small, to think far beyond what is reasonably foreseeable when they're crafting their policies and procedures, to be incredibly extra careful, if you will, and they won't do that if all of those things now become admissions.
Well, Your Honor, that same argument was raised in the Publix case. I don't want to put my finger on it right here, Mayo versus Publix, and that was rejected by the 4th DCA, and said, you know, when these policies are relevant, they can come into evidence.
Was that related to causation or duty?
It was related. It was related to causation. It wasn't related to duty.
Counsel,
because,
that seems like a totally different ballgame then.
well, my point simply being that companies haven't stopped making policies because they're admissible. And it is not unprecedented to consider policies in the foreseeability. In fact, this court in the Foster versus Poe folks case acknowledged that they said the restaurant had a policy of escorting employees to their cars, raising an inference management was aware of potential dangers. So, and the same happened in Nichols versus Home Depot. The defendants did not come into court and deny foreseeability in Nichols, so we didn't have to look at it in terms of duty. But Nichols, the court said that the policies and the manager testimony made it perfectly clear that that Home Depot foresaw these dangers. And, you know, if you look at the big picture, Walmart's policies have already been used to show foreseeability in other states. And we're not asking this court to say that Walmart had a duty to only confront the shoplifter in the way that its policies did. But we're asking it to say that if you acknowledge that harm from pursuing shoplifters and escalating encounters with shoplifters is foreseeable, that you don't get to come into court and say it's not. And
But again,
in
doesn't
the
that beg
duty
the question,
context,
is it an admission that it's foreseeable, or is it simply someone who is really smart thinking about things far beyond what is reasonably foreseeable and trying to avoid even the things that are beyond it? You see what I mean?
there's a line there, but I don't think companies are going to spend time creating policies.
Fair enough. Fair enough. Maybe they won't. Maybe they'll do the right thing and not and still have these robust policies. Fair enough. But it's still, if the point of a policy, right, is to think far beyond what is simply reasonably foreseeable, how is that an admission then that it's reasonably foreseeable? By definition, the policy is supposed to go far beyond what is reasonably foreseeable.
Who says that's by definition?
Well,
I mean, if
I'm
you're
asking
allowed,
you.
I don't think it is by definition. I think companies are creating reasonable policies. I mean, you're not going to tell your employees to take 17 steps to get
So it's your position that the policies themselves are only ever address what is reasonably foreseeable and never go beyond that?
Yes, Your Honor, because I don't think you would put into writing, here are the steps that you need to follow, because there might be a waiting accomplice in the car. They might use the car as a weapon, that these are signs that someone is not going to be peaceful. Why would you put those very detailed things into your policies if you didn't recognize that the harm befalling those things were very foreseeable? These aren't outside, like, I can't even think of an outside example here, but these aren't outside the realm of possibility as shown by the case law. I mean, 2 of the cases that we cited of the 6 from out of state show that Walmart has already gone up on appeal in cases where they have been held responsible for escalating encounters with shoplifters who have harmed their patrons. This is not out on an island.
Well, counsel, I'm a little confused because you seem to suggest that industry standards weren't a part of what we're talking about today. And I thought the standard under McCain was you look at the facts of the case, you look at testimony, you look at expert reports if it was timely provided and so forth, you look at industry standards, because you have to come up with what the standard is in the industry to figure out what the tort standard is. Right? I mean, it's like a medical malpractice. There has to be a standard medical malpractice. Well, what's the standard of security here, or safeguarding patrons? So I'm confused when you're saying that this isn't about industry standards.
Well, Your Honor, I don't see applying a Markowitz-type analysis, even aside from McCain, but the Markowitz acknowledgement that you, as a shopkeeper, are in a special relationship with your patron to foresee potential harms and to take actions to avoid them as necessitating a standard of care, an industry standard analysis. But where we do get into where the briefing did go in that direction was showing that across the country, we had 6 different cases that show, courts are coming out repeatedly saying it is foreseeable that a pursued shoplifter will flee. And there was actually a case that we cited, I believe, from West Virginia that expressly distinguished Graham and Lentini type cases, because in those cases there was no pursuit and the shoplifter had been peaceful. And
counsel, we've given a lot of time, about
yes.
30 seconds to wrap up, and then you have not addressed the cross appeal, so I'm going to deem that have been at least not addressed. And so if you can just give some final summation, we'll conclude for the day.
Okay, yes, Your Honor, thank you. We would ask the court to reverse and allow this case to proceed before the jury on duty, but affirm on the cross appeal. Thank you.
I want to thank both counsels for taking the extra time with us. This is an interesting case, important case, and have a safe day. We'll be in recess.
All right.